Hello, this is Dental Practice Risk Management through Regulatory Compliance, Part 4. TSBDE Rule 108.5, Understanding and Avoiding Patient Abandonment. My name is Boyd Shepard. I'm a director of the Professional Resources Office in the PACE Center, in the Office of the Dean, here at the UT Health, University of Texas Health Science Center at Houston School of Dentistry. I am also a clinical associate professor in the Department of General Practice and Dental Public Health. As a disclosure, please know that I receive no financial benefits that would create a conflict of interest or restrict my independent judgment with regard to the content of this presentation. At any time, while viewing the video streaming course, you can take a break by simply pausing your computer. At the completion of this section, you will be asked to take a short exam in order to complete the requirements for streaming video courses. At the time, you will receive instructions regarding taking the exam. Dental Practice Risk Management through Regulatory Compliance, Part 4. Texas State Board of Dental Examiners Rule 108.5, Understanding and Avoiding Patient Abandonment. This online course is designed for dental practitioners to gain a greater understanding of the Texas Dental Practice Act and the rules and regulations of the Texas State Board of Dental Examiners, specifically Texas State Board of Dental Examiners Rule 108.5, Patient Abandonment, so that they may implement the appropriate changes and systems in their day-to-day practice that ensures regulatory compliance with these rules and laws. Through understanding and implementation, the participant will also be managing the risks inherent in modern dental practice. Okay, let's get started. Dental Practice Risk Management through Regulatory Compliance, Part 4, TSBDE Rule 108.5, Understanding and Avoiding Patient Abandonment. The Texas State Board of Dental Examiners performs three primary functions. Number 1, licensing of dentists and dental hygienists. Number 2, annual registration of all dentists, hygienists, and labs. And number 3, enforcement of Texas laws regulating the practice of dentistry. Where in the world do you find the state board rules? The best place to access the state board rules as well as the Dental Practice Act is from and directly on the State Board of Dental Examiners website. To get to the website, simply Google search Texas Dental Board or Texas Board Dental. Any combination will take you to the Texas State Board of Dental Examiners website. On that website, there is a link in the top bar that specifically says Laws and Rules. At that location, you'll find the Dental Practice Act, the Texas Administrative Code, which is also known as the Board Rules. On the State Board website, you will also find board policy statements, the best example of which is the board's policy statement with regard to the use of Botox in a Texas dental practice. The board has an excellent list of frequently asked questions and answers to those questions, as well as forms that the board uses not only in their procedures but recommended forms for you in your office to help with compliance with state board rules. All of this is at the Texas State Board of Dental Examiners website. However, please caution. It is important to understand that new rules are always being proposed without notice to you. It is very good practice to check the Texas State Board of Dental Examiners website often And also, you can subscribe to the TSBDE newsletter to receive information and updates directly from the State Board of Dental Examiners. Again, the Texas State Board of Dental Examiners website has a lot of useful information. Here we are highlighting that part of the information available are the recent rule proposals will actually be published on the State Board website, and these rule proposals can be tracked as well as commented on by the public or certainly the profession, the licensed doctors. Also, it is important to look under the link for the laws and rules, not only for the Dental Practice Act and the rules of the board, but there you can see the rules that have been recently adopted and added to the rules by the State Board. And there in those sublinks you can also see the links for policy statements of the board as well. Again, it's very easy to access this information. Simply type in Texas Dental Board in Google, and this will take you to this website where you can locate all of this information. So, to get started, that is exactly what we'll do. We'll start in the Laws and Rules section of the board website. Specifically, we're going to the TSBDE rules link. We will click one of the two links to access the rules. And in this particular video, we're going to Chapter 108 of the State Board Rules, which is Professional Conduct. And then once we click that link, we will go to this page. We're going to be looking in Subchapter A, Professional Responsibility. And then specifically under Professional Conduct, Subchapter A, Professional Responsibility, we will be looking today at Rule 108.5, Patient Abandonment. You can see in this particular page the additional rules that are available under Chapter 108, Professional Conduct. For Rule 108.5, Patient Abandonment, the most important takeaway from this video, from this instruction, and the strategy that you should always use is to follow the format of the rule precisely. The State Board of Dental Examiners in this particular rule has done a great job providing the outline of the patient termination letter that may be necessary for you to send to your patient. So, if you find yourself in a particular situation where you have a conflict of interest with a patient, a conflict of interest in any number of things that may arise in your dental practice and in your business, ranging from patient no-shows or patients not paying their fees or your fees. It might be patients disagreeing with your recommended treatment, and particularly in wanting something that's outside the standard of care. It could also range as far as patients who are aggressive or abusive towards you or your staff. Any of these reasons would be the just cause for you to send them a termination of treatment letter pursuant to Rule 108.5. And that is the point. The Rule 108.5 of the State Board Rules is titled Patient Abandonment. Really, what the rule is about is the legal and proper way to dismiss a patient from your practice. This is the entire rule at a glance. Again, you can see how it lays out much the same way the format of your termination letter should read. We'll be looking at each part of this rule individually and then pulling it together in an example after we look at each component part of the rule. Again, the strategy is follow the text of the rule in formulating your dismissal letter. So, looking at each part of Rule 108.5. Also, as we look at this particular slide of this rule, 108.5, patient abandonment, and as you look at the full context of the entire rule at one glance, please note at the very bottom the source note. The provisions of this Rule 108.5 adopted to be effective February 20th, 2001, and then again proceeding amended to be effective April 14th, 2002. I like to point this out about any particular state board rule so that doctors understand the exact chronology and timing historically of how long particular rules have been in effect. This particular rule became effective in 2001, and then it was amended and changed and became effective in its amended state in April 14th, 2002. And this refers back to the slides that we reviewed earlier where I advised you to keep track of proposed rules and changes to rules. You'll also note in the source note where it references what's called the Texas Register. The Texas Register is where you would be directed on any particular proposed rule, where you can make comments about a proposed rule that may affect whether or not that proposed rule is actually adopted by the state board. Essentially, you have an opportunity to participate in the process. So thank you for the opportunity to point out that technicality and procedural part about board rules using this rule as an example. Again, I want to emphasize, and as you'll see throughout the course of this video, that the idea and the strategy is to follow the text of the rule in formulating your dismissal and discontinuance letter. I can advise doctors on the telephone, via email, face-to-face, through CE presentations, and through videos like this, and it seems that I cannot emphasize this enough. The tendency and the practice of most doctors, even though they understand and they've heard what I've said about following the text of the rule, formulating the dismissal letter, is that they will do a pretty good job of following the rule, but they will leave something out. And so when I say follow the text of the rule in formulating your dismissal letter, what I mean to say is you follow every single part and every single word, every single element, and every single requirement of the rule without leaving any part of it out, regardless of whether you think it applies or not. Technically, the investigators and the lawyers with the Texas State Board of Dental Examiners, if they are investigating and reviewing a case which involves an allegation of patient abandonment or dismissal or termination of a patient, they will be reading your dismissal letter if in fact you knew and did send one. And you may start off your letter excellently and say that your letter is being sent pursuant to Rule 108.5 and proceed, but if you leave out any component, any element, any requirement that is listed as you see here on the screen, when you look at the entire rule at a glance, if any one of these items is missing from your letter, technically, and I have seen it in particular cases, you could find yourself being in violation and disciplined for being in violation of Rule 108.5. So, again, I emphasize, not only follow the text of the rule in formulating your letter, but specifically follow the entire text of the rule in formulating your dismissal letter. Rule 108.5, Patient Abandonment, Subpart A. A dentist, without reasonable cause, shall not abandon a dental patient. Once a dentist has undertaken a course of treatment, the dentist, absent reasonable cause, shall not discontinue that treatment without giving the patient adequate notice and the opportunity to obtain the services of another dentist. A dentist shall exercise the level of care necessary to prevent jeopardizing the patient's oral health during this process. Looking at this particular part of the rule in more detail, with the particular words of note highlighted in red font, the first part that we want to talk about is without reasonable cause. This is important. A dentist without reasonable cause shall not abandon a dental patient. In reality, a dentist should never abandon a dental patient. And even with reasonable cause, you're not allowed to abandon a dental patient. Rather, with reasonable cause, you may dismiss a patient, or as stated in the rule in the next part that's highlighted, you may or shall discontinue treatment once you give the patient adequate notice. The rule is written in the negative. Once a dentist has undertaken a course of treatment, the dentist, absent reasonable cause, shall not discontinue that treatment without giving the patient adequate notice and the opportunity to obtain the services of another dentist. Stated in the positive, once a dentist has undertaken a course of treatment, the dentist, with reasonable cause, may discontinue that treatment as long as they give the patient adequate notice and the opportunity to obtain the services of another dentist. Continuing, a dentist shall exercise the level of care necessary to prevent jeopardizing the patient's oral health during this process. And really, the last sentence states the full intent of the rule. It's basically saying, if you have a reasonable cause, you may dismiss a patient from your practice. You may discontinue the treatment that you've begun. But in doing so, you must take care of the patient and exercise the level of care necessary, making sure that their oral health is not jeopardized during this process. That is the intent of this rule. So keeping in mind the intent is the best interest of the patient as you terminate their treatment and you discontinue their treatment in your office, you may then continue with the drafting of the termination letter. Rule 108.5, Patient Abandonment, Subpart B. Under this section, a dentist shall give a minimum of 30 days written notice of his or her intent to discontinue undertaken treatment. Notice shall be either hand-delivered to the patient or sent via certified mail, return receipt requested, to the patient's last known address, with the dentist retaining a copy of the notice letter in the patient's file along with proof of service. Looking at Subpart B in more detail, under this section, a dentist shall give a minimum of 30 days written notice. This is how your letter will start, and we'll look at that example, but you will be telling the patient that this is their 30 days written notice of your intent to discontinue undertaken treatment. The rule states that you can hand deliver this notice. However, I recommend that you do not hand deliver to the patient, and practically, you most likely will not have that opportunity. Rather, the better practice is to send the letter of dismissal and discontinuance of treatment via certified mail, return receipt requested, to the patient's last known address. Of note here is, in the example below, you see images of what a certified mail green card looks like. You fill out the green card front and back, which are the left and middle images, so that you will receive the green card back in your office once the patient retrieves the dismissal letter from the post office, or they will sign off when it is delivered to their either home or place of business. You will retain the receipt, which is the image on the far right, in your office, ideally stapled to your copy of the letter, which you have placed in the patient's chart. That way you have a record of the date and the address that the certified mail was sent to. You have the tracking number attached to the letter, which should also have the tracking number typed onto the letter, either above or below the address of the patient. And the green card will come back to you once delivery is completed and the patient has signed off and dated the receipt of the letter, and the postmaster or the postal person will make sure that the green card gets back to you. A couple of things of note. The Postal Service does not always get the green cards back to you in the mail. Occasionally they get lost or misdirected. The fact that you have the receipt on your end, the image on the far right, attached or stapled to your copy of the letter in the patient chart should suffice as evidence that you did comply with the certified mail return receipt requested obligation stated in the rule. Another thing of note is where it says to the patient's last known address. This is important because patients do move without giving notice to dental offices of their new residence or address where they receive mail. All the board requires is that you're sending the certified mail to the patient's last known address, which should be proved and evident from the address that you have stated in your patient chart. That's the only obligation that you have. You don't have an obligation to research or investigate to confirm the known address of any particular patient, but rather your legal record of your patient chart and the last known address stated in the chart is all that's required by the rule. And then obviously the last part of the rule is something we've already mentioned, that the dentist must retain a copy of the notice letter in the patient's file or chart along with proof of service, service being the green card that comes back, which again 95% of the time that it does, but if it doesn't, you'll make a note that the mail was not received. A couple of other notes here. Number one, the rule requires either hand delivery or certified mail. I'm recommending that you always do certified mail, but certainly in addition to certified mail, you can send the notice letter by regular mail to make sure that the patient receives the letter. You can also send a copy via email. But please note, if you send by regular mail and email, it does not relieve you of the obligation under the rule to send by certified mail. If you find yourself in the midst of a complaint investigation based on Rule 108.5 patient abandonment, and if you did not comply with either the hand delivery or the certified mail components, even if you can show that you sent it by email and it was responded to, or even if you can show somehow that it was received by regular mail, if you did not comply with the technicality of certified mail, technically you will not be in compliance and you will be in violation of Rule 108.5. So the certified mail is the part that's a must, and then just as a part of due diligence and practically, you could send by regular mail as well, or by email. The contents of the dismissal and discontinuance letter pursuant to Rule 108.5 patient abandonment must include the following items. Adequate notice shall include the following. Number 1, a short description of the patient's current status, including the patient's current diagnosis and a summary of the patient's current treatment plan. However, when you get into this part, you can simply restate it. A short description or a summary of your present and future needs includes the foregoing items that have been listed. Adequate notice shall include also, number 3, an explanation regarding the consequences of non-treatment. Whatever the consequences of non-treatment are, those should be listed in your letter, depending on the treatment plan, depending on the particular diagnosis, depending on the particular status of treatment, depending on the particular point in time that you are in treatment, whether or not they are in temporaries, anything that has to do with what their current status is, what they need to have done going forward, treatment-wise, and the consequences of that non-treatment needs to be articulated in this letter. Number 4, adequate notice shall include a recommendation that the patient continue care with another dentist. This particular part of the rule merely says that you must or shall include a recommendation that the patient continue care with another dentist. You can restate this sentence exactly in your termination and discontinuance letter. The rule does not require a referral. You are not required by the law to refer to any specific dentist or any number of dentists. Rather, you only have to make this statement. I recommend that you continue care with another dentist, period. Adequate notice shall also include, number 5, a clear statement emphasizing that the dentist is available to provide any emergency treatment necessary to prevent patient harm during the 30-day period. This is the 30-day period of the written notice. And you must conclude with a clear statement stating that you are available to provide any emergency treatment necessary to prevent patient harm during the 30-day period. Now, patients and their definition or interpretation or perception of an emergency may differ from the doctor's understanding, perception, and definition of an emergency. The rule states that you only have to be available for emergency treatment necessary to prevent patient harm. So if a patient calls, a patient that you've sent this termination and discontinuance letter to, and it's during the 30-day period, my recommendation is you default to the position that says, I'm going to be available to this patient for emergency treatment. But at the same time, you evaluate, is this emergency treatment necessary to prevent patient harm, or is it not an emergency situation and the patient just needs to be educated and I don't need to actually appoint and see this patient. For some situations, this will be the temptation for doctors to look for any reason or out of having to appoint for emergency treatment, because after all, they are trying to discontinue or terminate the patient from the practice. My advice is to err on the side of the patient during the 30-day period, to cleanly move on and effectuate the termination and discontinuance of a patient, regardless of the level of the emergency. And if in fact there is an out, it may be better practice to go ahead and see the patient to make sure that there was nothing that was actually an emergency, and to make sure that later you cannot be criticized for not being available during this 30-day period. In other words, default and err towards the side of the patient during this time. After the 30-day period has run, you'll be able to say, I'm no longer obligated towards this patient one way or the other. Subpart C of Rule 108.5 re-emphasizes the 30-day availability for emergencies. That's how important this particular part of the rule is. A dentist shall remain reasonably available to render any emergency treatment necessary under B5 of this section for up to 30 days from the date of such notice. What's important here is certified mail typically takes 3 days under the Postal Service for delivery once it's put in the mail to be sent. Legally, this is the period of time that's recognized for the delivery of certified mail. If you put your certified mail to the patient in the mailbox or at the post office, let's say according to the image of the calendar on the screen, on the 4th, you can mark your calendar that most likely and legally it will be considered delivered on the 7th. This is important because remember what I said before, that sometimes the green card gets lost or misdirected and may not come back to your office, and all that you have is the little green receipt that you've retained stapled to your copy of the letter in the patient chart. So when you drop the mail in the mailbox, and on this example it would be Monday the 5th, you would actually be circling Thursday the 8th on this particular calendar, because you are recognizing the 3 days that it takes certified mail to be delivered. And that's important because you now need to calculate 30 days from your delivery date or your anticipated delivery date. The green card you may not get back until the following week, and you need to know sooner than later what your 30-day run is so that you can note the chart of when your last date of obligation will be. So in my recommendation, it's actually not available for 30 days from the date you drop in the mailbox, but really 33 days from the date that you drop in the mailbox. And then you can wait and see if you get the green card back and compare the 30 days to the date that was signed by the patient on the green card. Patients may not go to the post office the date that it's available to pick up from the post office if they were not available to receive the certified mail at their home. Again, the strategy with the rule is to follow the format of the rule. It's laid out perfectly. Use all of the wording that's available and do not miss any subsection of the rule. The board will look that you met all of the elements and all of the items listed in the rule. If you do not cover any one area, it could result in a violation of Rule 108.5 and a disciplinary action. So, as an example, the classic example is what I call the grumpy denture patient. This is the patient who you have referred to an oral surgeon for the removal of a maxillary torus, and they need to have their maxillary denture remade, and in the meantime you have relined their maxillary denture as a temporary until they can get or have a new denture completed that better conforms to the new anatomical structure now that the maxillary torus has been removed. However, the grumpy denture patient always knows more than you do. The grumpy denture patient always knows how to best take care of their dental needs better than their dentist. And they would rather show up unannounced for occasional and frequent relines of their current denture rather than go through the process of getting a new denture that fits better, because quite frankly, again, they know better than you do. So you've advised the grumpy denture patient that you need to do a complete new denture, upper and lower, but they insist that they're just going to have relines done and that that will be sufficient. In the meantime, the grumpy denture patient not only shows up for these relines in conflict with your recommendation, but they show up frequently without making appointments, and at some points in time even become aggressive or abusive towards your office staff with a sense of entitlement, so bad that they even feel compelled to come and find you in your office in an operatory without waiting in the reception area, but just walking on back and finding you and announcing they're there for a reline. That is a pretty extreme case with reasonable cause to dismiss a patient from a practice. So, now that you have reasonable cause to dismiss this patient, and because you've tried to work with them and explain to them that, look, this is what you need and please don't show up at my office unannounced, but they continue to do so, you've been left no choice but to send them the Rule 108.5 discontinuance or termination letter. Dear grumpy denture patient, obviously you would use Mr. or Mrs., their first or last name. I am sending you this letter pursuant to Texas State Board of Dental Examiners Rule 108.5. We have reached an impasse with your treatment as you are not following my recommendation. Additionally, and you can list additional items that may include their showing up for appointments unannounced even though they've been asked not do so. Additionally, you continue to present yourself in my office without an appointment, and you are abusive towards my staff as they attempt to assist you. For the foregoing reasons, and with reasonable cause, I am hereby terminating our doctor-patient relationship. Please be advised of the following. Please be advised that, number one, you are currently post-surgery for the removal of a large maxillary torus. You are currently utilizing your previous dentures with relining in the maxillary plate, and your current treatment plan based on my recommendation is that you replace both your upper and lower dentures. Number two, your present and future needs includes replacement of both your upper and lower dentures. Number three, the consequences of non-treatment include that you will experience an ill-fitting denture, potentially leading to oral ulcers and possibly infections of the ulcerated areas. I recommend that you continue care with another dentist, and I remain available to you to provide any emergency treatment necessary to prevent harm during the 30-day period from the date of your receipt of this letter. Thank you for your understanding, and please advise my office if we need to forward your dental records to your new dentist, and if so, the address to send them to. Best regards, your name. And this is a great example, and a classic example, of how to follow Rule 108.5, patient abandonment, which technically is the instructions and the legal way to terminate and discontinue treatment of a current patient. And then conclude with, thank you for your understanding, and please advise my office if we need to forward your dental records to your new dentist, and if so, the address to send them to. Best regards, and then your name. A couple of things to note before we leave this particular slide. You can see how formulating this letter can be very direct and very straightforward, and actually very easy as long as you follow the template, the example, and the wording of Rule 108.5 exactly. There's nothing in the rule that requires that you be prepared to send dental records to the new dentist. However, what goes hand in hand with this particular Rule 108.5 is the obligation in Rule 108.8 that if a patient requests a copy of their records pursuant to Rule 108.8, you do have a duty to comply with that request within 30 days of the request. And that request could be verbal, it could be in writing, and there's no obligation that the patient must sign a receipt for it. In that particular Rule 108.8, once a patient requests, even just verbally, a copy of their records, you, the dentist, have an obligation to get a copy of that record to them within 30 days. For the purposes of this Rule 108.5, even though 108.5 does not require the forwarding of those records, it's just a nice add-on to the letter to let the patient know that you will forward those records as soon as they advise you of the location of the new dentist. Another thing to note here as we look at this conclusion of this sample letter is that patients, when they receive a termination or discontinuance letter, most often they take the letter at face value. They're not offended. They understand that there is a conflict. They just as soon move on as well, and they will begin looking for another dentist to complete their care. Some patients, however, will become offended, will become disgruntled, and this might result in their retaliating by sending a complaint to the dental board or contacting a lawyer or something like that. This is something that does happen from time to time with certain patients. However, the anticipation of that with any particular patient is not a reason to not send the termination and discontinuance letter. You have to manage the situation one step at a time. If a patient does complain to the state board as a retaliation to receiving Rule 108.5, then obviously it was a great reason and you're in good shape because you did send the Rule 108.5 letter, which re-emphasizes the importance of making sure that you comply with each element and each component of the letter. Additionally, patients may state that they never received the letter, which is why it is so important to comply with the certified mail requirement of the rule. That puts you in a position to prove that the letter was in fact sent. If the green card comes back to your office attached to the original envelope, that means that the patient did not go to the post office to pick up the certified mail, but rather the green card remained attached to the letter, and the postal service will then return the entire letter with the green card still in place back to your office. This again is your proof that you complied with the requirements of the rule. You do not have to resend the letter by certified mail at this point. At this point, you've done everything that the rule requires technically. However, this is why I advised you in the beginning to send the letter also by regular mail. you're going to want the patient to get the message. You're going to want them to get the letter. Some patients are obstinate and they know they have certified mail waiting for them, and it's their habit and their policy, and in all likelihood, intentionally, they did not go pick up the certified mail because they know that it's just the certified mail version of the regular mail from you that they've received already. The certified mail and the green card coming back to you all in one piece is your proof that you complied with the rule. You would then take that returned letter, you would not open it, you would leave it sealed, you would leave the green card in place, and you would attach it to your copy of the letter in the chart. And you know, if you followed my advice, that the patient received the termination letter by regular mail, and therefore you should still remain available for the next 30 days. And if they do call, obviously you can confirm that they are aware of the termination period. But you have your legal proof, the green card attached to the original certified mail envelope letter, that you complied with Rule 108.5. I've only seen it a couple of times where the technicality of following the rule came down to the proof of the green card and the receipt and the return of the envelope. But it was very, very important to that particular case that all of these elements were met in order to defend the doctor against the allegation that they did not properly terminate the patient. So, again, follow the strategy of the rule and understand the importance of each component part and how it helps you in the defense of an investigation of Rule 108.5. Remember the strategy. Follow the format of the rule. If you need any clarification, if you have any questions about any part of the foregoing, please send an email to utsdcontinuinged@uth.tmc.edu. This has been Dental Practice Risk Management through Regulatory Compliance, Part 4, TSBDE Rule 108.5, Understanding and Avoiding Patient Abandonment. You can find TSBDE Rule 108.5 as illustrated in this video on the State Board website at this link. This completes Dental Practice Risk Management through Regulatory Compliance, Part 4, TSBDE Rule 108.5, Understanding and Avoiding Patient Abandonment. It is time for you to take a short exam in order to complete the requirements for streaming video courses. Due to the nature of our subject content in this video, a passing score of 90% is necessary in order for you to pass the course. Upon a successful completion of this exam, you will be visually informed that you have met the requirements to proceed. If you fail to answer enough questions correctly, you will be instructed to take the exam and a new set of questions will be provided. You will have 3 chances to fulfill the requirements. If you are not successful, you will be instructed to review this section again. Good luck on the exam. If you are ready to take Dental Practice Risk Management through Regulatory Compliance Part 5, TSBDE Rule 108.6, Understanding How and When to Make a Report of Patient Death or Injury Requiring Hospitalization, upon the completion of this exam, you will be provided a link to continue. If you wish to proceed at a later date, you will need to log in and no further payment is necessary as this is a continuum.